Generally, a person who wrongfully intrudes into another person's life, solitude, or seclusion may be liable for the tort invasion of privacy. In addition, there are generally four different forms of invasion of privacy: unreasonable intrusion upon seclusion, commercial appropriation of name or likeness, public disclosure of private facts, and false light publicity. But has this tort always been recognized by courts? In the 1902 case, Roberson versus Rochester Folding Box, the highest court in New York considered whether a woman could recover for invasion of privacy after she unexpectedly found her picture in a flower advertisement. The Franklin Mills Company was a business based out of New York that manufactured and sold flower products. In addition, Franklin Mills retained the Rochester Folding Box Company to run advertisements for its products. In the early 1900s, a young woman from New York named Abigail Roberson discovered her portrait on flyers advertising Franklin Mills flour. In fact, there were approximately 25,000 flyers that were printed, posted, and conspicuously displayed in stores, warehouses, saloons, and other public places without Roberson's consent. Many people commented on the flyers and often ridiculed or mocked Roberson when they recognized her face. As a result, Roberson was humiliated, became physically and mentally ill, suffered a severe nervous shock, became bedridden, and was forced to call a doctor. Subsequently, Roberson sued Rochester in New York Supreme Court for invasion of privacy, seeking $15,000 in damages for her injuries. Further, Roberson asked the court to enjoin Rochester from further using her image and likeness in any form whatsoever. In response, Rochester filed a demurrer, seeking dismissal of the complaint for failure to state a cause of action, which the court overruled. Following a bench trial, the court entered judgment for Roberson. Rochester appealed to the New York Supreme Court Appellate Division, which affirmed. The Appellate Division certified the question of law to the New York Court of Appeals.